Thank you, Chava. Good morning, everyone. I would like to begin by thanking the organizers for inviting Child Rights International Network to speak on this critical issue today. Over the next 15 minutes, I will be focusing on where we currently stand in terms of securing environmental rights for children, some of the challenges and some of the ways that they could be overcome. On to the next slide, please. I'll be drawing extensively from CRIN's projects, Access to Justice for Children's Environmental Rights, specifically addressing children's access to environmental justice. We are researching how legal systems across 45 countries, including 13 European states, enable or hinder children's ability to seek remedies for violations of their environmental rights. We focus on 4 key areas: protection of children's environmental rights within national law, children's access to courts, available remedies for violations, protection of civil and political rights that impact access to environmental justice, including protest restrictions and access to information rights. On to the next slide, please. So to start with the basics, what law needs to be in place to protect children's environmental rights, and what does that look like in practice around the world at the moment? To start at the highest level, in most jurisdictions, we've seen a rapid increase in the number of countries establishing or clarifying constitutional rights related to the environment. Portugal was the first one to explicitly set out this right in 1976, followed by Spain. Since then, over 100 countries, including many in Europe, have followed suit. If we look at Europe, while most countries uphold the right to a healthy environment at their national level, there is no overreaching regional protection. Constitutional provisions on environmental rights are generally broad and rarely make specific reference to children. But when these rights are well integrated into a legal system that enables direct enforcement and allows children to do so, the lack of explicit mention isn't necessarily an issue. A 1994 case in the Philippines is an example of this. A group of children, alongside the Philippine Ecological Network, sued the Department of Environment and Natural Resources to halt timber licenses, arguing for their right to a healthy environment. While the case did not stop logging, it set a key legal precedent by affirming that the right to a balanced and healthful ecology and the right to self-preservation and self-perpetuation under the 1987 Constitution were enforceable in court, including by children. In some countries, these direct opportunities aren't present. Take the United Kingdom, for example, a very different case. Unlike most countries, the UK doesn't have a codified constitution, and its human rights laws don't explicitly include environmental protections. That doesn't mean environmental litigation isn't happening, but it does mean that legal challenges can't be framed in the same direct rights-based way. As we move down to the national legal hierarchy, laws become more numerous, introducing a variety of more detailed regulatory frameworks. I would like to focus on one policy area that significantly affects children, but it's inconsistently protected. Policies specifically addressing childhood exposure to toxic substances, as well as the systematic inclusion of child-specific effects in pollutant capture and release registers, remain far less common than they should be. Why does this matter? Well, children are particularly vulnerable to pollutants, which can cause serious developmental issues. If these are not explicitly considered in pollutant registers, the impacts of toxic chemicals on children are not systematically addressed. This also poses a challenge in legal cases where children need to demonstrate harm caused by such exposure. Determining the threshold for what constitutes harmful exposure can become a key issue in these cases as well. On to the next slide, please. Now let's move on to the practical challenges children face when seeking justice for environmental rights violations. Children are rarely in a position to afford legal advice or representation, yet is it essential if they are able to access and rely on justice systems to provide remedies for rights violations. Some countries impose a very high limits on liability for environmental cases. meaning the potential costs of litigation are very, very high. Providing free or affordable legal support tailored to children's needs can make a huge difference in ensuring they can access justice. Similarly, removing financial barriers in environmental cases, such as the excessive liability limits we mentioned, can ensure that individuals, particularly children, have a fair chance to seek justice and uphold their rights. With that in mind, let's now turn to how the legal system can grant children the status to enforce their environmental rights. A lack of independence and legal status is commonly a serious barrier for children accessing justice for any issue. In some ways, the way that a state formulates its rules on how children can make complaints reflects its broader perspective on their rights. Are they empowered, or are they just thrown into the shadow of their parents? It is almost universally recognized globally that children can bring cases in their own names. What is less clear across the board is how they are able to do so and the role that they are permitted to play in legal proceedings. Blanket provisions requiring all people under a certain age to act exclusively through a litigation guardian or a similar person are common, while more nuanced rules that take into account the individual capacity of a particular child are a bit more rare. In environmental cases, we have seen some of the most creative and boundary-pushing developments in who is able to bring a case. It is a common basic rule of standing globally that in order to bring a complaint, an individual must be specifically affected. This, taking to literally, would pose a problem in environmental cases because the scale of the problem is so big that it actually affects everyone. We've already talked about some of the ways that constitutional protections have been interpreted to enable all individuals to take legal action on environmental protection. But some jurisdictions have taken a step forward. In the Philippines, in 2015, we saw a case emerge in which an NGO sought to act on behalf of marine mammals, claiming that oil exploration was causing disruption and harming their food sources. While the Supreme Court did not grant the animals themselves standing, it ruled that every citizen, as steward of nature, has the right to bring such a suit. This decision also allows children to bring similar cases on behalf of environmental protection. Many of the most successful complaints have adopted this model. Take, for example, the groundbreaking Urgenda case in the Netherlands, requiring the government to cut greenhouse gas emissions by 25%, which was brought on behalf of 886 Dutch citizens. We've also seen this model used in more specific cases, challenging large-scale infrastructure projects on environmental grounds, an approach that has long been a key feature of environmental litigation. It is worth noting that in around 70% of global climate changes, at least one NGO is involved, either as the sole party or alongside individuals or groups of individuals. Granting standing to NGOs focused on either children's rights or environmental protection can help safeguard children's rights. However, the procedures which enable organizations to take public interest or collective action cases are not consistently available. So once standing has been established and children have a foot in the door, one of the next big challenges is who has to prove what and to what standard. This can be a particular challenge in cases related to children's exposure to toxic chemicals and pollution. In most cases, the burden of proof falls on the victims. They have to demonstrate a clear link between their exposure to harmful chemicals, the alleged polluter, and the health effects they suffer, even though these impacts may take years or even decades to manifest. However, there is a significant imbalance of power in these situations. Individuals, and particularly children, will rarely have access to resources and information about hazards and exposure to toxic chemicals that the companies producing them will. In 2017, the UN Special Rapporteur on Human Rights and Toxic Wastes made a call for exploring ways of rebalancing this issue to enable victims to access remedies, and we can see some of the ways of approaching this issue emerging in some countries. One approach is to apply strict liability in certain environmental cases, meaning that the polluter's intent is irrelevant. In Belgium, for example, in certain toxic exposure cases, a claimant is required to demonstrate that they have suffered damage and that there is a causal connection between the damage and the perpetrator. But there is no need for any further evidence of fault. Other countries, such as Thailand, have introduced a flexible approach to the burden of proof so that it doesn't solely fall on complainants. In 2019, the Supreme Court of Thailand ruled that the claimant could demonstrate high probability that the harm had been caused. The burden of proof then moved to the defendant. So, building on what we've just discussed, children still lack access to adequate and age and disability responsive information about the effects of environmental harm and climate change. The UN Committee on the Rights of the Child has acknowledged that accessible information is crucial for children to access justice. However, state approaches differ. Some countries like France, Germany, and Sweden have no specific provisions on children's right to access information. And even where this right is legally recognized, some limitations may apply for children. If appropriately elaborated and curated in line with and respect of children's rights, pollution information portals can constitute powerful tools to provide information. While some states have these registers in place, our research has not found any examples in Europe that take into account child-specific factors in terms of which data is gathered and the type of data generated. Environmental education is also crucial for children to properly understand what climate change, pollution, hazardous chemicals, and their environmental rights are. A final practical challenge I want to highlight is the issue of limitation periods or strict deadlines for filing cases. This is particularly problematic for children whose ability to approach the courts may be delayed until they reach the age of majority. Moreover, the health effects of environmental harm often take years to become apparent or are just simply hereditary, making it harder to build a strong case. On to the next slide, please. So there's a lot to be said on innovative remedies in this context, but I would like to focus on implementation challenges, and I'm happy to give you examples during the question and answer part on innovative remedies. But let's move to challenges of implementation. The growth in rights-based and children's rights-based litigation has been very significant in recent years, and new ground has certainly been broken in terms of the law. But one of the challenges that follows this litigation is implementation. To briefly take the example of the Klima Signorinen case, which was one of the most significant within Europe last year, the European Court of Human Rights clearly found that Switzerland had violated the rights of older women by not taking steps to combat climate change. The Swiss government is now arguing that its current law meets the standards set down by the court already, and so no further action is needed to implement the judgment. I don't propose to go into detailed analysis of this case, but to make the point that the legal developments in groundbreaking litigation don't necessarily lead to changes at the national level. Litigation has undeniably had success, but it isn't an end point in itself. On to the next slide, please. Thank you very much for your attention, and I'll be happy to answer any questions you may have.